Waterboarding. Is it torture? I mean, as it existed in the CIA interrogation program? No, it's not. And I feel very liberated now at being able to say that. When that question first came up when I was having my confirmation hearings, and I was asked to say that I thought waterboarding was torture. At the time, I did not know precisely what technique was used in the CIA program, and the torture statute is a criminal statute. It's very specific. It says that somebody is guilty of torture if, under color of law, they inflict severe, not just pain, but severe physical or mental pain or suffering under color of law. And they have to do it with specific intent to inflict severe physical or mental pain or suffering. Since I didn't know precisely what technique was used and what its effect was, I couldn't very well say that. And they didn't particularly appreciate the fact that I pointed out that they had the chance twice, not once, but twice, in Senate votes to define waterboarding as torture, and they declined to do it. They wanted me to do it for them. And I said I wasn't going to do that. Was roundly attacked for my refusal. Later on, when I had my first oversight hearing, I did know what the technique was, but I also knew that it wasn't then part of the CIA program. The only reason that I'm able to comment on it now is that my successor has disclosed the entire CIA program, and the memos underlying the Justice Department's analysis of it has disclosed them publicly. So now the terrorists know precisely what the limits are of what it is that we can do to them under color of law and what it is that we're willing to do. I think that was an enormously unwise thing for him to do, but he did it. And so now I can tell you that waterboarding, as it is in the CIA program, involves strapping somebody to a board and pouring water over their nose and mouth, and if necessary, cupping their mouth so that they don't throw their head from side to side, for a period of not longer than 40 seconds in a minute, over a period that is defined strictly as to time. You can do it only a certain number of times within a certain period of time. And there's a physician standing by and a psychiatrist standing by to make sure that no ill effects are suffered by the person undergoing the waterboarding. The fact is that we waterboarded, count them folks, 3 of the people we apprehended. Just to give you an idea of what the scale is here, there were tens of thousands of prisoners taken by the U.S. Armed Forces. Of those, about 1,000 were turned over to the CIA for questioning. Of those, a couple hundred were subjected to what were called, and what I think is one of the worst marketing campaigns since New Coke, called enhanced interrogation techniques. You know, enhanced sounds like a wash day product. You know, you want to buy the enhanced product. I think they should have been called harsh interrogation techniques, because that's what they were. They should have been called whatever you want, but not enhanced, because it sounded as if somebody was trying to. It's enhanced as a verbal flinch. It sounds as if you're trying to cover up something that is illegal or that you have reason to be ashamed of, whereas we didn't. And nobody could be approved for those techniques unless we were well aware that they had access to significant information. And then those techniques were applied only under a certain protocol and with very strict limits. And as I said, there were 3 people who were waterboarded. Khalid Sheikh Mohammed, a man named Nashiri, who was the architect of the attack on the Cole, and whose military trial has now been postponed by the administration in one of those Friday summer releases that they release news hoping that nobody will notice. He was scheduled to be tried before a military commission this summer, as a matter of fact. His trial has now been postponed, and I would suggest to you that that's probably prefatory to his being turned over to civilian authorities instead of the military commission. He was the second. And a man named Abu Zubaydah was also waterboarded. All 3 of them gave us enormously valuable information that prevented attacks. So the program was successful. It was not torture, not as defined in the statute. It may very well have violated or have been in violation of statutes that were passed subsequently. And so if it had to be reinstituted, it would have to be reevaluated. But it was not a violation of the torture statute, which was the only relevant statute on the books at the time. And if the memos show anything, it is the extraordinary lengths to which the Justice Department went in order to avoid subjecting anybody to torture. In fact, there were techniques that were suggested by the CIA that were ruled out by the Department of Justice as going too far.